So hello everyone and welcome to the digital community of the Franco-British Chamber. My name is Jérôme Testu and I'm head of communications and marketing at the Chamber. And this morning we are delighted to welcome Clarisse Delettre, a French lawyer registered at the Nantes Bar, who leads Majorel Mobility, that is the international division of Majorel Avocats. So today's topic is secondment, compliance in managing the mobility of employees, seconded to France and the UK. So we look forward to Clarisse's presentation on this subject. But first of all, very quickly, I'd like to remind you that the Franco-British Chamber is 150 years of existence at the service of French and British companies developing on both sides of the channel. We operate on several levels: networking through events, more than 50 a year, lobbying public authorities, and think tanks on topical issues. If you're not a member yet, please contact us to find out how we can help you. But without further ado, I give the floor to Clarisse. If you have any question, please don't hesitate to ask them via the chat, and Clarisse will answer them at the end of her speech and presentation. Please also remember to put yourself on mute. I wish you a great conference. Clarisse, the floor is yours.
Thank you, Jérôme. Thank you for this nice introduction. So you said everything about myself, so I guess I can begin. But just briefly, my law firm, Majorel, is an employment law firm. So we assist companies in France, but also abroad with all matters in relation to employment law and social security law and business immigration. This morning, we are going to talk about a very technical legal subject matter. So secondment, that we call also posting of workers, and more specifically about the compliance in managing the mobility of UK employees seconded in France. So we are here for a little bit more than 30 minutes together to go into these complex subject matters. Of course, I will not be able to give you a full lecture of the secondment law, but the main highlights, and to give you the signals to have in mind and the topics that you should address when dealing with the mobility of UK employees in France, especially since the Brexit. So the main questions we are going to examine together this morning are the following. What is precisely a secondment situation, a posting situation? So we will see that there are several schemes that can involve a secondment. What is, legally speaking, a seconded employee? We will see that the definition of a seconded employee is not really the same in terms of employment law or in terms of social security law. What are the main obligations for the British employer and the French host company? To what extent are the sending and receiving companies jointly responsible of the workers? What is the duty of vigilance? What are the penalties for non-compliance, and so on? So there are numerous questions, and I will try to be the most exhaustive possible. If you have any question during the presentation, do not hesitate to raise your hand. So to begin with, a very important definition. What is a seconded or a posted employee? A seconded employee is an employee of an employer who regularly carries out his activity in a country A. So let's consider it is United Kingdom, and who, working usually on behalf of the British company, carries out a work at the request of his British employer for a limited period of time in France. So it's very specific for many reasons, and the definition is quite long and has several items that we will explore a little bit further. The employer established abroad in the UK continues to pay the remuneration. So it means that the employment contract is ongoing, is not suspended, it's not an expatriation, it is a secondment for a limited period in France. And posting of workers involves to deal with several legal subject matters, of course, employment law, and we have to switch between UK and French laws for some aspects. So it requires you to deal with the several regulations, social security law, immigration law, tax law, but also insurances, for instance. So the posting of workers involved a lot of various subject legal matters, and it creates very consequently a high complexity, a legal complexity, but also an operational one, because all the following rules we will see this morning are very known, sometimes by the head of the company, but in practice, on the day-to-day life of the company, posted workers feel sometimes a little bit alone in France and not very friendly or accompanied by their foreign employer. And as it is very complex from a legal standpoint, it creates a high risk of non-compliance and of sanctions. So in labor law, we have, generally speaking, four main situations that we qualify as a posting of workers. The first one is a performance of a service, of a subcontracting situation. So it can be an industrial, a commercial, craft, liberal, agricultural activity carried out under a contract with a service provider. So you have a contract between the British company and the French host company in the framework of a service provider agreement. This is the first situation. And of course, there are numerous between the UK and France. The second one is a scheme intra-group mobility. So here we are talking about the secondment of workers between companies that belong to the same international group for an assignment, a freestyle assignment, a mission, or a training, for instance. So it can be the employees of the British headquarters that are sent during six months into the French subsidiary for a specific mission, or just because it's part of an HR employee way to be trained within the group. We have also what we call the on-account operations. A company established abroad, whether or not it has an establishment in France, can temporarily second its employees to France for one-off assignments. And finally, the secondment of temporary staff. I will not go into details for this last scenario because it's even more complex than the other rules we are going to see, but let's keep that in mind. So to go into the details of the subject matter, so the posting of British employees in France. What are the pre-requirements to send British employees in France and to benefit from the secondment scheme? A British company may post workers in France if the three following conditions are fulfilled. So the three following conditions are all to be fulfilled. It's not to pick one and not the other one. So we have first the fact that the company posting workers in France should have substantial activities in the country in which it is established, like the French labor code. So it means what is having a substantial activity in the home country is at least 25% of sales in the home country. Second point, the work contract in the UK shall remain in effect during the whole period of posting in France. So the British employees remain a British employee of the British company. There is no suspension, no termination of his employment contract during the time of the mission in France. Very important. And it is forbidden to hire someone on the purpose, the sole purpose, to post it in France. The third condition is the following. The posting period must be of limited duration. So as I said, we are not in an expatriation scenario where an employee is sent for, I don't know, 5-10 years abroad. The posting period has to be limited, and we say it should not exceed 12 months. So we'll see after why 12 months is a very important threshold when we are talking about posting. Before posting, there is, of course, some administrative and legal tasks to be fulfilled. The first one is to fill a pre-declaration to the Labor Inspectorate in France. Maybe you know that already. It's called a CIFC declaration. It means that the British employer that is willing to post British employees in France has to provide the Labour Inspectorate in France with a prior declaration of posting before the deployment of the workforce. So the posting declaration is made on a specific website. You have to use an online service CPC, and there are some information to be given to the French administration to explain the framework of the posting. If you are not doing that, there is a high risk of administrative penalty. If the prior declaration of posting is not sent, the employer may receive a fine of up 4K per posted worker. Here, I wanted to share with you the content of the CPC declaration so that you will see the details of the declaration and the fact that you have, as a British company, a lot of information to provide to the French authorities. Of course, you have to explain the activity of your company, the why you are posting people in France, in which framework, how long, information about the posted employees themselves, information about your status, your corporate status in the UK. You have to prove that you are a good employer and that you have paid all your employees' social security premiums in the UK, and so on. So it's a very important declaration. And of course, you have also to designate a representative of the company in France, and to give the identity of the representative, the statement of acceptance by the firm, start date, duration, and the designated agent in some cases. So you'll see that the list of informations to be given are quite similar between the intra-group provision of service or posting and the supply of interim employees, and that there are a lot of them. So you have to be very careful about that. In some cases, hopefully, there are exemptions. So no CPC is required when you are posting on your own account. It means that the posting of employees on the employer's account alone does not require any prior declaration of posting, nor the appointment of a representative. So it can be, for instance, if one British employee is going in France to attend a conference, a meeting, is not sent, is not posted by a client, is not sent in the framework of an intra-group mobility. It is sent for two days, for instance, in France to attend, I don't know, the agriculture salon in Paris currently. So it's very specific. But we have also exemptions for posting for short-term services. So this is very useful in practice on the day-to-day business life, because for posting of short-term services, you don't need to fill this CPC declaration. There is a precise list of activities that are listed by the French Labour Code, and it specifies the maximum duration of activity allowed in France in this specific framework. So it mainly concerns athletes, members of the team accompanying them. So let's talk about Olympic Games in your mind, official delegates, but also researchers or teachers speaking at conference, seminar, or scientific events. So it can be useful in some cases. Then I wanted to share with you a very important point: the fact that when you are a British company that you are willing to send British employees in France, you will have to respect some French provisions in terms of employment law, and it can be very difficult to use this, because you will have, from one side, your British employment contract and the British employment law that you know very well, but also you will have to comply with what we call the core set of rules of the French Labour Code. I put this morning on my slide the main provisions you will have to respect in France from the first day of the posting. So the first day your workers are in France, in the framework of the contracting agreement, for instance, or within an intra-group mobility, you will have to respect this list of French legal provisions. So, of course, the individual and collective freedoms at work, discrimination and professional equality between men and women, maternity protection, work conditions and guarantees due to workers employed by temporary work agencies, the right to strike, and so on. But also, very important, working time. And we know that French working time is sometimes a nightmare to deal with, especially when it comes to compensatory rest periods, calculation of overtime hours, night work rules, etc. So it can be very tricky. And in such cases, you have to compare the current British employment rules you are applying to the British employment contract and the French labor provisions, part of the core set of rules, to make sure that your employee has not been deprived from a French labor provision that will apply in case of secondment. The remuneration is also very key in such schemes of posting, because you have to respect the minimum remuneration in France. The rule is the following: rule equal profile, equal pay. So it means that you have to fight against the social dumping. And of course, you have also to fight against any form of illegal work. You will have to comply with such core set of rules provided by the French labor provisions, but also to comply with French extended collective bargaining agreements. So the CBA, as we call it, are collective agreements negotiated by unions in France, and that applies to all companies working in a specific field of activity. So maybe in the industry, in the grocery, in the, I don't know, chemistry sector. So we have plenty of them, and you have to respect the French extended collective agreements. So this is for the first part of the French provisions to be respected in France. So from day 1 to 12 months, you have to apply the core set of rules, which is already quite a lot, in fact, as well seen. But it gets it more complex when the posting duration is more than 1 year. More than 1 year of posting, it means that you will have to apply all legal provisions set forth by French employment law, regulation, and CBA. So this is very huge and very complicated to apply in practice, because as maybe a British legal director, you know very well the British legal provisions, but not very well the French ones. And you will have also to give a precise and complete individual information to all posted workers to explain and to inform them of their rights in France during all the posting. Every posted worker also be granted an information document stating for the applicable French provisions, as well as a description of the way he or she could enforce his rights in France. Finally, for employees working in the construction sectors, they will have to ask for a professional ID card. We call it in France carte BTP. This BTP card is mandatory and has to be held by any posted worker working in the construction sector. So during the posting, so once you have done the CC declaration, okay, you know that you have to comply with some rules of French employment law. Well, it's already a huge part, but now you have to keep in mind that during all the posting period, the British company, the employer, have to keep a list of documents to be shared to the French Labor Inspectorate in case of control. So the British company posting workers in France has to keep at the workplace the documents listed by the French Labor Code. There are plenty of them. I just wanted to highlight the main one. So you will have to provide, in case of control, documents relevant to the posted workers themselves. Their work permit, if it is mandatory, medical certificates, pay slips, documents proving the payment of remuneration, working time sheets, indicating for each employee the hour of the beginning of work and the hour of the end of work and the daily duration of work. So you will see it's a lot, in fact, because every month you have to make sure that all those documentation are ready in case of a control. And you have also to provide documents relevant to the substantial activities of the British company in its country of establishment. So mainly it's a certificate for payment of social contributions and employment contracts of the posted worker. And of course, you have to provide the CC declaration. And these documents must be translated in French and the amounts must be converted in euros. So there is a lot of administrative stuff beyond all that regulation, the day-to-day management and of compliance of the posting situation. I wanted also to share with you some views about immigration rules. Of course, before Brexit, there was no real question about immigration because British employees could come in France and work freely in the framework of the EU regulation. Since the Brexit, the rules are very different. And the posting of workers is a frequent risk of non-compliance in terms of immigration. The risk is to be in a situation of illegal employment of foreign workers. So, for instance, without a work permit. The French Labour Code says, and it's a very important provision in the French Labour Code, no one may directly or indirectly hire, keep in their service, or employ for any duration a foreigner who does not hold a permit authorizing them to work in France. So it's a very broad tradition because you see that it is said directly or indirectly. So it refers directly to a posting situation. And since the Brexit, British nationals cannot anymore benefit from the freedom of circulation with the European Union, and they need to comply with French immigration legislation in terms of visa, residence card, and work permits. Of course, as many other foreigners, for less than 3 months of secondment, British nationals do not need a visa. They are exempted to present a short-term visa if they come in France for less than 90 days. So it is very useful in the day-to-day business life because they can come for very short-term missions or to attend a meeting without making a lot of immigration formalities. But for more than 3 months of presence in France, they will have to apply to a long-term visa depending on their situation. So I summarize here the main long-term visa they could apply in case of posting situation. So the main one are, as you will see, the multi-year residence permit called ICT, intra-company transfer, which is valid for up to 3 years, but non-renewable. So it is very useful in a situation of transfer of employee within a group. So for the intra-group mobility, it is the main used one. And as you have seen, as it is limited to 3 years, it will stick to the fact that secondment is not for a long period of time. But you may also sometimes need to obtain a multi-year residence, a temporary residence permit called temporary worker. So it depends really on the situation and how long the worker is going to be posted in France, in which framework will it, if it is an intra-group mobility of or a service provider agreement. It depends also on the level of remuneration, of the seniority of the employee. So there are several criteria that you have in advance to list and to address to determine which type of long-term visa this person will be able to obtain. Another very important question is whether or not a work permit has to be obtained before the posting of the British employees in France. So a work permit is called in France an autorisation de travail. It is a document delivered by the French administration that explicitly states that an employee, a foreigner, is allowed to work in a specific company for a specific period of time, specific remuneration, and it's very precise. What is complicated is that a work permit cannot be obtained in 2 days. So in terms of management of the posting of employees, it implies you to think about a time frame. A work permit can be delivered in 2 days as it can be obtained after 2 months. So it is very important to keep immigration in mind because it is really time consuming and it's complex. It will not be very fun if there are no exemptions to this obligation to obtain a work permit. So no work permit is required for missions of less than 3 months in some areas listed by law, and it is audit, expertise assignments in IT, management, finance, insurance, architecture, and engineering as a seconded employee. So this extension can be very useful for posted workers, British posted workers in France, in missions of less than 3 months. You can, in some cases, be exempted of visa and of work permit. And so you don't need to make a lot of immigration formalities. You only need to comply with the 60 declarations. So it's really a way to ease the mobility of British employees in France. And I also wanted to highlight the famous case law that is sometimes useful in posting scenarios. It is the famous Van der Helst case visa. So the Van der Helst ruling is a ruling of the European Court of Justice, specifically for non-European posted workers that require an immigration procedure. So it's only in the framework of the provision of services within the European Union, and it says that the work permit will not be required for provision of services in the European Union when a sub-country national is holding already a valid EU residence permit. So it's quite complicated. So maybe I should give you an example. Let's consider a British employee of a British company. He spent in the Spanish subsidiary of the group, and he stays there for a long period of time, maybe, I don't know, 4 years, 5 years. So the British employee in Spain has obtained a European residence permit. So he is able to live and to work in Spain since many years. And now the group is willing to post this person, this British employee, in France by a client under a service provision agreement for, I don't know, 1 year. And the question is my British employee holding a Spanish residence permit, authorized to work freely in France? The answer given by the European Court of Justice is that no work permit is required. So it's very useful in practice, but we have to be very cautious about this ruling because the French prefecture, the French administration, in some cases, doesn't know it very well and doesn't know when it can be applied or not. And sometimes we have got some refusal of application of this ruling, which is quite tricky because we have then to explain to the administration, and it takes a lot of time, and sometimes it is not very simple to organize the posting of employees. Another very important subject matter is the social security. The principle of territoriality says that I pay social security contributions where I work. So it means that if you are a British employee posted in France, theoretically, the main rules would be that you have to pay social contributions in France. Another European regulation says that employees moving within the EU must be subject to a single social security legislation. So British employee cannot be affiliated to the British social security system and at the same time to the French social security system. You have to make a choice. And post-Brexit, the principle has been retained in relations between the UK and the European Union countries, including France, in the framework on the Trade and Cooperation Agreement, which is very a good thing because British employees are able to benefit from the Secondment regulation, which enables British employees to remain covered by the British social security system during the posting assignments in France. So they can stay affiliated to the British social security system and not to the French one if the following two conditions are met. The employee must not be sent to France to replace another worker, and the employee's planned stay in France does not exceed 2 years. So the maximum social security secondment situation is 2 years. Here you see that there is a difference between the employment law regulation about posting of employees and the social security one. For British employees, social security says it is maximum 2 years of secondment to benefit from the British social security system. After the 2 years, the British employee has to be affiliated to the French social security system, and the British company, who remains the employer, has to pay the French social security contributions in France, which of course is quite complicated because in terms of payroll, we will have to appoint a French payroll provider and to issue pay slips that are compliant in France. Also, a certificate of coverage that we call A1 certificate has to be obtained to justify the secondment situation, the fact that the British employees remain affiliated to the British social security system during all the posting period. So as I said, if the conditions for the posting are not met or not anymore, the affiliation to the French social security system is mandatory. And if the British company doesn't have any legal entity in France, it requires the British company to register to a center called CNFE. It's the National Centers for Foreign Companies in France, which is competent to this specific case. And we recommend very frequently also to opt for a complementary private insurance or coverage in case of work accident abroad. So social security matter is very important. Now I wanted to make a short focus on the duty of vigilance and of the obligations that are on the shoulders of the French legal entity receiving the British posted workers. So the French company is not passive in this relationship. It has to be very vigilant about the compliance of the British company. There is first a verification obligation. It is a material obligation that requires the ordering entity, so the French one, let's assume it's a French entity, to obtain a certain number of documents, the CPC, the A1, the payslips, the proof of payment of social security contributions, for instance, from the British company. And the failure to comply with this obligation is a material element in the criminal offense of illegal employment. So it's very important for the French company to be vigilant before the posting, during the posting, and at the end of the posting, that the British company is compliant itself for all the posting scenario. In addition, failure on the part of the ordering party to carry out the verification directly exposes the French company to financial solidarity. It means that in case of control of the labor inspectorate, if the British company is fined as a penalty, the French company can also be responsible in this framework. There is also an obligation to issue injunctions. So if the French company discovers that the British company is not compliant, the French company has to say, hey, you have to be compliant with that rule, and do it in a very short period of time. Otherwise, I do it myself. So I can, as a French company, I can take the lead to make the situation compliant and, for instance, to fill the CPC declaration. Also, in case of work accident in France, it is the French company that has to declare it. The French company has also an obligation to preserve the legal and economic autonomy of the service provider and to make sure that there is no economic dependence of the British subcontractor with the French company. And there is an obligation to ensure that the service provider has sufficient human and material resources. The risks in case of non-compliance are numerous. Of course, there is the reputational risk, which is increasing these days, because in France, you may know that there is the preparation of the Olympic Games, and that the French government has issued a plan to be a plan that focuses a lot of posting scenarios. And we know that the labor inspectorate in France will launch a lot of control of those situations of posting in France. The sanctions can be fines, but also suspension of the work assignment, exclusion from public contracts, cancellation of state financial aids, criminal penalties in case of illegal work or in case of hiring foreigners without a work permit, and the co-responsibility for the host French employee. To end this presentation, I wanted to share with you some HR guidelines in the way you can monitor the compliance of posting scenarios. So how do I manage a secondment scheme? You have to be, of course, very vigilant about the applicable legislation, so between the UK one and the French one, to organize a regulatory watch, so maybe every month, so to make sure that all documentation are available and compliant. Time management is really key, because we have seen there are several subject matters to address, in specifically the immigration aspect that you don't underestimate, because it often determines the rest of the procedure, and it takes a lot of time. You will have to coordinate a lot of contacts, maybe an immigration lawyer, a legal law advisor, tax advisor, corporate one, and this is quite complex sometimes to harmonize all subject matters. Cost management is also very important. Sometimes it is useful to make a comparison between a settlement scenario, but also an expatriation scenario, anticipate the salary cost, extra salary cost, for instance. Sometimes posted employees are willing to negotiate the salary and to ask for a specific bonus during the posting period. There are some questions with the tax residence, if the British employee is spent during a lot of time abroad. In some cases, it may change his tax residence. And of course, you will have to communicate very well and to coordinate actions between the UK subsidiary or subcontractor on the one side and the French subsidiary or contractor in the other side. So posting is really an HR challenge, a day-to-day challenge. You may find a lot of questions around the posting scenario. For instance, the situation of the employee's family needs to be taken into consideration in some cases. If the spouse job search taken care of by the company, for instance, or the removal organized and financed by the employer. And it is very advisable to frame the contractual side of the mobility and to draft a secondment rider to the employment contract in the UK, for instance, to describe the scope of assignment, so the purpose of the posting, duration, who is the customer, what is the reporting line for the posting employees when they are in France. This document also explains the legislation applicable during the assignment. So the fact that the main rules will be the British ones during all the assignments, but that in France you will have also to respect the set current rules. The reader to the employment contract generally explains the impact of the mobility on the applicable social security system and on the remuneration. But you can also anticipate the end of the posting and the fate of the employee at the end of the assignment. Is it a repatriation, a reclassification, or is the employee sent in another country? So there are a lot of subject matters to address. I hope that the presentation was clear and that it gave you a good knowledge of the main legal subject to be addressed during the posting the posting scenarios when it is during an intra-group mobility situation or a service provider one.